Exercise start. High Court of Patna also lays down that once a suit or appeal dismissed for default was restored by the order of the court, all ancillary orders passed in the suit or appeal before its dismissal also revive and operate since that date with all their legal implications. Full stop. It has been observed that the effect of the restoration was the same as if there were no dismissal of the suit and only the order of dismissal is set aside and all pending proceedings and orders were revived, including the order that the suit was to proceed ex parte against the applicant. On restoration, the parties were in the same position in which it was just before the dismissal. Para change. In my opinion, a consideration of the aforesaid authorities leaves no room for doubt that the principle of Rule 9 contained in Order 38, which has been held as applicable to attachments before judgment, does not apply to other orders where no such specific provision exists. Full stop. As a result, the interlocutory orders which terminate on the decision of the suit on its dismissal in default will revive on the setting aside of the dismissal either by the same court or by a superior court, since the legal effect of setting aside is to restore the proceedings of the same stage and point at which they were pending immediately before the were interrupted by the dismissal. Full stop. Any other construction would reduce the proceedings of the court to a murky, because if the submission of the appellant were correct, it would logically follow that every time the suit is dismissed in default and restored, and for that matter, an ex parte decree or order passed and set aside, the fresh proceedings must start ever again, including the passing of orders for issue of notice to the non-applicant defendants who had been proceeded ex parte, or orders closing the evidence or disallowing or allowing a commission or any question in examination of the witness. Full stop. Such a result is surely not intended by the provisions of principles of law. Next para. My conclusion, therefore, is that on the restoration of a petition for eviction either by the controller or by the appellate tribunal, the interlocutory orders passed before the dismissal of the petition under section 15 of the act would revive and the proceedings would commence from the stage at which they were pending before the dismissal. Full stop. Consequently, the tenants are bound to comply with the said order and cannot contend that it had lapsed and needed to be passed again, full stop. It may, however, be clarified that during the period the eviction petition remained dismissed until it was restored. The operation of the interlocutory order would remain suspended, and any default alleged to have been committed by the tenants during the said period will not render them liable to any penalties attaching to non-compliance with the said order. Full stop. Nevertheless, no sooner than the petition is restored, the interim order revives and the tenant must deposit all arrears of rent then due and refrain from committing any further default in compliance with the order except at his peril. Full stop. The rent controller tribunal in the impugned order has taken good care of this point, and the appellants had not been penalized for any default committed by them during the period occurring between the dismissal of the petition and its restoration under the orders of the appellate tribunal. Full stop. The defaults with which the appellants have been charged were those which had been committed by them long after the main petition for eviction had been restored. The appellants have therefore clearly violated the terms of the order passed under Section 15 of the Act.